Okay, Your Honor, you are good to go, and recording privileges are granted, so you are good to start whenever you're ready.
Your Honor, I believe you're muted.
Thank you. Good morning. My name is Jason Goss. I will be the presiding judge today, and we do have two other scoring judges that are in the room. They will stay on mute, so you won't see or hear from them. I would like to call the case of Marks versus Sonny's Rooftop Bar and ask the attorneys for their appearances. Okay, so we got Charlotte Hill for the plaintiff. And we have, is that Asia or Aja?
It's Aja.
Aja. Thank you, Ms. Moore. Aja Moore for the defense. All right, for everybody else and anybody watching, please put your, I guess, your view into speaker view, because we are about to start our opening statements. We will take the opening statement from the plaintiff first. So Ms. Hill, you will be able to open whenever you're ready, unless you have any other pretrial matters you'd like to address with me.
Your Honor, before we begin, may we address a few housekeeping matters?
Sure.
First, Your Honor, we'd like to invoke Rule 615 of the Federal Rules of Evidence, constructively sequestering all witnesses barring party representatives. In today's case, we will have no party representative.
Okay. Defense?
Just a few more, sorry, Your Honor.
Well, let me see if the defense has an objection.
Oh,
Because,
okay. Sorry, thank you.
sure.
No objection, Your Honor. I would just like to recognize Sunny Mehta as our party representative here today.
Okay, so you would like Sunny to be able to remain in the courtroom while everyone else is excluded?
Yes.
Okay, that will be granted with the exception of the party representative for the defense.
Next, we'd like to draw Your Honor's attention to the pretrial order signed by Judge Pasquarello. Stipulation 2 states that this case will be a bifurcated trial. We'll only be dealing with the liability of the defendant, and damages will be held in a separate proceeding.
Okay.
And going in line with that same pretrial order, evidentiary ruling 13 states that at all times relevant, Frankfurt Johnson and Sunny Mehta were acting on behalf of the defendant, Sunny's Rooftop Bar. Frankfurt Johnson was a bartender at Sunny's, and Sunny Mehta was the bar owner.
I understand.
And just one more thing, Your Honor, since this is our first time in Your Honor's virtual courtroom, may we ask your preferences in regards to sharing demonstrative aids and exhibits? Would you like us to ask for permission or just to let the record reflect?
Yeah, I would like to ask for permission just so I know what's being shown or what's about to be shared.
Yes, Your Honor. That's all from us, Your Honor. We're ready to proceed.
All right. Any housekeeping from the defense?
Yes, Your Honor. I would like to bring the court's attention to pretrial stipulations 14 and 16. Pretrial stipulation 14 states that Jessica Marks was born on January 20th, 2000. And stipulation 16 states that all photos taken from Morgan Levitt's phone were taken on March 24th, 2019, thus making Jessica Marks 19 years old at the time of the incident in question here today.
I got it. I think I understand where y'all are going with it. Thank you.
Got you. And just one more thing, when evidence is presented on the screen, could it be considered to be constructively outside of the view of the jury until it's entered into evidence?
Sure. You mean that so that you can show the witness so that they can see it?
Yes, Your Honor.
Yes, that'll be fine.
All right, and with that, the defense is ready to proceed.
Okay. Plaintiff, opening statement.
Yes, Your Honor. Your Honor, Ms. Moore, members of the jury, may it so please the court. They sold, they saw, They stood still. It's March 24th, 2019, and a woman named Jessica Marks couldn't be any happier. She's at one of the most popular bars here in LA, called Sunny's Rooftop Bar. Some of you might have been there before. She's there celebrating her last day of spring break. The food is good, the dance floor is full, even her best friend is right there with her. Everything is perfect. But 3 hours later, Jessica Marks is dead. And now, how does a healthy young woman go from happily celebrating her spring break to dying in a car crash in just 3 hours? Well, you're going to learn today that the defendant in today's case is that bar, Sunny's Rooftop Bar. You're going to learn that on March 24th, 2019, Jessica Marks was only 19. You're going to learn that this defendant continued to serve alcohol to an obviously intoxicated minor. Now, what Miss Marks didn't know was that this defendant's employees saw how intoxicated she had become. What she didn't know was that even after seeing how drunk she had become, they still chose to serve her drink after drink after drink. What she didn't know as she was being served drink after drink was that she would be the one to pay the price. That's why we're here today. Today, we've brought a claim of wrongful death under a specific California statute called the Dram Shop Act. It's a law that says bars, like this defendant, can be found liable if a minor dies from being served alcohol. And now today, our job is to prove that it's more likely than not true that this defendant is liable for Miss Marks's death. We'll meet our burden by showing you that this defendant sold alcohol to a minor, that they saw Miss Marks become obviously intoxicated, and that they stood still, even after seeing her become drunk. First, this defendant sold alcohol to a minor. Today, you're going to hear from Miss Marks's best friend and the only person who was with her that night, Miss Morgan Levin. You'll hear Miss Levin testify that Miss Marks, a 5-foot, 110-pound girl, was served a bottle of wine, 3 hard seltzers, a beer, and a shot of whiskey, all in a 3-hour period by this defendant. Second, you're going to learn that this defendant's employees saw Miss Marks become obviously intoxicated. And now Miss Levin's going to tell you that only an hour into Miss Marks's drinking, Miss Marks fell down the stairs, and the bar's owner, Sonny Mehta, had to catch her and say, "Whoa, we may need to cut this one off." But you're going to learn that they didn't. Because that third point, that this defendant's employees stood still. You're going to learn that after serving Miss Marks all of those drinks, they watched her walk out of the bar. At the end of this trial, the evidence will be clear. This defendant is liable for the death of Jessica Marks. And now at the end of this trial, I'll ask you to find this defendant liable because they sold, they saw, and they stood still. Thank you.
All right, thank you, Ms. Hill. Ms. Moore, do you have an opening statement?
Yes, Your Honor. Could you give me a few seconds to readjust my camera?
Sure, take as much time as you need.
May I proceed, Your Honor?
You may.
We all make choices, but in the end, our choices make us. May it please the court? Members of the jury, a few moments ago, you heard Plaintiff Attorney Hill say that Sunny's Rooftop Bar overserved Jessica Marks and ignored the signs of obvious intoxication. You also heard Ms. Hill tell you that Sunny's Rooftop Bar chose to serve Jessica Marks drink after drink, Yet, what Ms. Hill failed to mention was how crucial Jessica's choices will be in deciding the verdict here in today's case. We, the defense, are going to tell you what really happened the night of March 24th. But before we do that, I'd like to talk to you a bit about the burden the plaintiff has in today's case. They must prove to you by a preponderance of the evidence that Sunny's rooftop bar knowingly overserved and ignored the signs of obvious intoxication in Jessica Marks. And members of the jury, they will not be able to meet this burden for several reasons. Firstly, today they're going to call Morgan Levin to the stand. And from Morgan Levin, you'll hear a plethora of things about the night of March 24th. You're going to hear that Morgan Levin had a few drinks herself the night of March 24th. You're going to hear that Miss Levin doesn't remember and even misremembers a lot of things about that night. And you're also going to hear that Miss Levin spoke with plaintiff's attorneys for upwards of 3 hours before giving her deposition. Now, you're also going to hear from Sunny Mehta, the only sober person that was there that night. And Sunny Mehta is going to say that some of the things Morgan Levin will testify about here today just didn't happen. And that is exactly why we are raising an affirmative defense of comparative fault here today. Comparative fault means that at the end of this trial, you will be asked to assign a percentage of responsibility to each party in today's case. And in doing this, we're going to have to ask you to do something that is monumentally difficult. Now, we know that Jessica Marks had a bright future ahead of her, but today the law requires that we remove our emotion from this situation and take a look at the facts. Today, it is your duty as a juror to take a look at Jessica Marks's choices as well. And if you find that they are a substantial factor in causing her death, then you must find Sunny's rooftop bar not liable. Now, members of the jury, like I said, you're going to hear from Morgan Levin, and Morgan Levin will tell you a bit about Jessica's choices. She's going to tell you that Jessica drank and Jessica drove. Jessica chose to order a lot of drinks that night, and then she drove again, which led to her tragic fate. But you're also going to hear from Sunny Mehta here today, who's going to tell you that they saw no signs of obvious intoxication. And you're going to learn why this is so. Now, members of the jury, Ms. Hill told you that they saw, they served, and they stood still. But members of the jury, Sunny Mehta is going to tell you why this is so here today, because they didn't see anything. Now, members of the jury, at the end of this trial, after both sides has presented their cases, we're going to ask you to do the right thing and find Sunny's rooftop bar not liable. Thank you.
Okay, thank you, Ms. Moore. Ms. Hill, do you have any witnesses for the plaintiff?
Yes, Your Honor. The plaintiff
right.
calls Morgan Levin to the stand.
I'm sorry, I didn't catch the name. Morgan Levin. Got it.
Morgan Levin, Your Honor.
Yes. No, thank you. You may proceed whenever you're ready.
Good afternoon, Miss Levin. Can you see and hear me all right?
Yeah, I can.
Would you please introduce yourself to the jury?
Of course. Hello, my name is Morgan Levin.
Do you know why you're testifying today?
Yeah, Jess was my best friend, and I was with her on the night that she died.
Well, could you tell the members of the jury a little bit about Jessica?
Yeah, Jess was perfect. I mean, she was this crazy studious kid. She was super interested in law. She actually would have been really interested in something like this, but she also had time for her friends overall. I mean, she was just amazing. She made me so proud.
How'd you two meet?
We met in junior high. It's kind of a funny story, actually. So we have the same birthday, right? And so we had two options. Either we could be enemies over the same birthday thing, or we could be best friends. And we decided ultimately it'd be best for us to be best friends.
Well, Miss Levin, you said you were with Miss Marks on the night that she died. Do you remember what day that was?
Yeah, March 24th, 2019.
I want to keep track of what happened that night. Your Honor, permission to display a blank timeline onto the screen?
Yes, ma'am, you may.
Now, Miss Levin, where were you two on March 24th?
We were in LA. We were hanging out there for spring break. I go to UCLA, and so she was visiting me.
Did you go to any bars that week?
Oh, yeah, we did. On the 24th, we went to this bar called Sunny's Rooftop Bar.
What time did you get to Sunny's?
We got there around.
When
9.
did you two leave?
We were there for around 3 hours, so 11:45.
I want to go through those 3 hours, Miss Levin, starting at 9 o'clock. Now, Miss Levin, I want you to take the members of the jury into that bar with you. When you first get in, do you go sit at the bar or do you go up to a table?
We went up to a table at the top on the roof.
Were there any employees serving you at this time?
Yeah, Sunny, the main owner of the bar.
Well, I want to break down your interactions with Mr. Mehta that night. Let's first talk about what was sold. Your Honor, permission to display exhibits 13 and 14 onto the screen constructively outside the eyeshot of the jury, as they haven't been admitted yet.
Sure.
Miss Levin, what are we looking at here?
You're looking at some of the food and the drinks that we ordered on that night.
Have these pictures been changed or altered in any way?
No, they look the exact same.
At this time, Your Honor, the plaintiff moves exhibit 13 and 14 into evidence.
Is there any objection from the defense?
None, Your Honor.
All right, 13 and 14 will be admitted.
Now, Miss Levin, of the drinks that are shown in these pictures, which ones did Jessica have?
She had wine, beer, and then 3 White Claws.
Were there any other drinks that Miss Marks had that aren't pictured here?
Yeah, she had a green tea shot.
And as Miss Marks began to drink all these drinks, did her behavior begin to change in any way?
Yeah, she started not acting like herself. She started slurring her speech a little bit, acting kind of stumbly. Her eyes got red.
Well, I want to focus on whether any employees of this defendant saw what you just described. And now you mentioned earlier that Sunny Mehta was serving your table. How many times was he there?
At least 8, maybe even 10.
Well, you mentioned that you saw Jessica stumbling. Can you tell us if there were any employees around while she was stumbling?
Yeah, Sunny saw actually because he had to help pick her up.
Well, what happened when he had to come pick her up?
Well, I mean, he didn't really do much. He just kind of laughed it off and said, well, we may need to cut this one off.
Where did this interaction happen?
This happened at the stairs of the bar.
And after the owner of the bar said, we might need to cut this one off, did they cut her off?
No, they continued to serve her.
Did you take any videos of Miss Marks that night?
I did, yes.
Would you recognize that video if I showed it to you today?
Yeah.
Your Honor, permission to display exhibit 10 constructively outside the eye shot of the jury as it hasn't been admitted yet.
You may.
Now, Miss Levin, I know this video isn't being played yet, but do you recognize the first frame of this video?
Yep, there's Jess.
Does it look to be changed or altered in any way?
No.
Plaintiff moves exhibit 10 into evidence.
Defense, is there any objection?
Yes, Your Honor, on grounds of 403, the defense contends that this evidence will mislead the jury and is more prejudicial than probative. May I be heard?
Oh, yes, ma'am, you may. I would ask though, does somebody mind playing it for me? Because if I'm going to analyze the 403, I probably need to see what it looks like first. Outside the presence of the jury.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Okay. Yes, Ms. Moore, I'll let you be heard on your objection.
Yes, Your Honor, this evidence would mislead the jury because, as you just heard in this video, Jessica was reenacting an Academy Award speech. She said, "I thank the Academy, I thank my mom and dad," and this implies that Jessica was acting. However, if this evidence is admitted, the plaintiff will lead the jury to believe that this is an accurate depiction of how Jessica was acting the entire night, which would be misleading the jury. And to address my more prejudicial than probative argument, the fact that this is the only piece of evidence that is here today of Jessica's behavior would prejudice the jury into believing that this is how she was acting the entire night.
Okay, thank you, ma'am. Ms. Hill, do you have any response to that?
Yes, Your Honor.
Okay, go ahead.
In order for something to be more prejudicial than probative under Rule 403, the prejudicial value must substantially outweigh the probative value. In this case, we've brought a claim of wrongful death. And one of the elements we must prove is that Jessica Marks was seen being obviously intoxicated. And in order to do that, we had to show that she was drinking and becoming intoxicated in the first place. Showing the jury what Ms. Marks was acting like makes the fact that Jessica Marks was obviously intoxicated more probable. Any prejudice value this exhibit has is far outweighed by the probative value. It's admissible.
I think I'm ready to rule. Ms. Moore, I do understand your objection. I think that it's a good objection. However, I do believe that because this is evidence of how she was acting in the bar and could lead to her intoxication, I believe that there is a higher probative value and it's not substantially outweighed by the prejudicial effect. However, Ms. Moore, I would expect you on cross-examination to maybe bring out some of those points that you're making about the fact that this is a short period of time, and it doesn't necessarily mean that anyone in the bar could have seen her at this point before she left. So with that, I will allow the exhibit to be admitted. Ms. Hill, you can play it again if you need to with the witness, or if you would like, since we've already played it, we can constructively assume that the jury has already seen it if you want to just continue asking us questions. However you want to do it is fine.
Yes, Your Honor, that sounds good if we can constructively assume the jury has seen it at this point, as I know Ms. Levin was also watching.
Absolutely, no problem.
Now, you testified earlier that you and Ms. Marks left the bar at 11:45. As you two began to leave, do you remember if Jessica still seemed drunk?
Yeah, she was still acting the same way, still slurring her speech, still stumbling. So I was really concerned, and I practically begged her to get into the Uber with me.
Did she get into that Uber?
No, she didn't. She instead got into her car and drove away.
What happened after Jessica got into her car and drove away?
She didn't really make it far. It was looking pretty good at first. She got on to the highway, but then she just out of nowhere swerved and crashed.
Ms. Levin, as you watched Ms. Marks walk out of that bar and get into her car, did any of the defendant's employees try to stop Ms. Marks from driving?
No, they really did nothing. They just stood still.
I'm sorry, Ms. Levin. Thank you for testifying today. No further questions, Your Honor.
Okay, thank you, Ms. Hill. Ms. Moore, do you have a cross-examination?
Yes, Your Honor, I'm going to move my camera again.
Okay, perfect. Proceed when you're ready.
All right, good afternoon, Ms. Levin.
Good afternoon.
Now, I'd like to start by talking to you about some things you mentioned on your direct examination. Now,
Okay.
you said that you observed Jessica that night with slurred speech,
Yeah, I did.
and you observed her talking obnoxiously loud.
Yeah, louder than usual.
Yet you can't name any specific instance where she exhibited these behaviors, right?
I mean, it was just more throughout the night, you know, as it was going on. I wasn't really keeping tabs on her.
You can't name any specific time in the 8 to 10 times you interacted with Sunny Meta.
No, because I mean, it was just throughout the night, you know, it was a kind of a gradual thing that like over the night, it kind of progressively got worse. And I saw that.
Okay, just to be clear, Ms. Levin, that was a yes to my question. You can't name any specific instances.
Not specific times, no.
All right, and now I'm going to talk to you about why you're testifying here in today's case. You are aware that the plaintiff today is Ethel Marks, your best friend's mother, correct?
Yeah,
And initially, when Jessica died, Ethel Marks threatened to sue you. Isn't that right?
yeah. I mean, I get it. It was her daughter. What I don't know what she would have. I think she was really hurting in that time. It just seemed like the most obvious answer.
Well, thank you, Ms. Levin. I didn't really ask what Ms. Marks thought. I just asked if she threatened to sue you. That was a yes.
Yeah, she did.
And then you later learned that instead, you'd be testifying here in today's case, right?
Yeah, about what I saw that night.
You also learned that you'd have to give a deposition.
Yeah, of course.
In preparation for this deposition, you spoke with Ethel Marks' attorneys, correct?
Yeah, of course.
For around 3 hours.
Yeah,
Then the day after this conversation, you gave your official deposition. Isn't that right?
yeah,
And when asked by my co-counsel, you said that you can only remember a general thing about this conversation, right?
I mean, it's kind of, yeah, the deposition itself was kind of a blur. I mean, it was extremely emotional. It was my best friend who died.
Well, you told my co-counsel that all you could remember from this conversation is that plaintiff's attorneys told you to tell the truth, right?
Yeah, I mean, that's really all that stood out because all I could think about at the time was the fact that Jess was just gone.
Well, and during this deposition, you said that your memory of March 24th was only pretty good, right?
Yeah, at that time.
You said the words, "I don't know," and "I don't remember" a number of times.
Yeah, and I mean, since they told me to be honest, I wanted to be 100% clear about what I did and didn't remember so that they understood everything.
Just to be clear, that was a yes.
Yeah,
And in this deposition, you referred to Jessica Marks as obviously intoxicated. Isn't that right?
yes. I mean, throughout the night, she was slurring her speech, stumbling. She fell down the stairs.
You used these exact words, Miss Levin.
Yes, I did.
All right. Now I'd like to talk to you a little bit more about Jessica. While she was in high school, Jessica drank every Saturday. Isn't that right?
Yeah, high school parties, you know.
And then when you got to college, she started to drink a bit more, right?
Objection,
the
Your
typ-
Honor, this is inadmissible character evidence.
All right. Is there a response to that? We'll go outside the presence of the jury. Ms. Moore, do you have a response to that inadmissible character evidence?
Yes, Your Honor. As you just heard from Ms. Levin, Jessica Marks drank every Saturday, thus making this a habit or routine practice under Rule 406 of Jessica Marks.
Okay. Is there a response to that, Ms. Hill?
Yes, Your Honor. They're offering this to show that because Miss Marks drank a certain amount in the past, that they must have been drinking the same way on the night of March 24th, 2019. And now Miss Marks drinking isn't an action. The state of Miss Marks being intoxicated or having a drink or two, that isn't a habit. It's an inadmissible.
I understand. Ms. Moore, I'm willing to go with you on the habit because I do think that maybe it's developed, but what's the relevance of the habit? Why do you need evidence of her prior drinking? What are you getting at?
Your Honor, if you may allow me to proffer, this goes to evidence to show that Sunny Meta is supposed to be a reasonable person here in today's case. And the fact that Jessica Marks drank alcohol many times in her past go to that fact that as a reasonable person, Sunny wouldn't have observed the signs of obvious intoxication.
Tolerance. I get it. That is relevant. Ms. Hill, I understand your objection. It's a good one, but I'm going to overrule it. I'm going to allow you, Ms. Moore, to ask about her drinking and her ability, I guess her tolerance to alcohol based upon her habit. Go ahead.
Yes, Your Honor. Would you like me to ask that question again, Ms. Levin?
Yeah.
I asked, did Jessica began to drink a bit more when she got to college? Isn't that right?
Yeah. She was getting introduced to the whole college party world.
And throughout high school, you had been Jessica's designated driver. Isn't that right?
Yeah.
All right. Now I'd like to talk to you about the night of March 24th. Your Honor, permission to display a timeline demonstrative of ours?
You may. Is it to the witness? You want to do a demonstrative?
Yes.
Okay, yeah, that's fine.
Now, but before I display that demonstrative, Ms. Levin, you recognize these drinks, correct?
I do.
This is what you and Jessica drank from before you left to go to Sunny's rooftop bar?
Yeah, it is.
And you recognize these photos to not be altered in any way, right?
Not that I can tell.
All right, Your Honor, at this time, the defense moves to enter exhibit 5 evidence.
Is there any objection?
No objection from the plaintiff, Your Honor.
Okay, then defense exhibit 5 will be admitted. You may proceed.
Yes, Your Honor. Now, at around 8:15, you and Jessica had a glass or two from these bottles, correct?
Yeah, we did.
You could add that to our timeline. And then, despite just having had 1 to 2 drinks, Jessica drove to Sunny's at around 8:30. Isn't that right?
Yeah, she was feeling fine at that point and she wasn't like showing any signs of being drunk, so she thought it'd be okay to drive.
All right, and you got there at around 9 o'clock?
Yeah.
That's when your tab opened?
Yes, that is.
It opened, and it stayed open till about 11:40, isn't that right?
Right, yeah, we spent 3 hours there.
And while you were there, you had 3 drinks, isn't that right?
I did, yeah.
So Jessica had around 6?
Yeah, they served her a lot.
Well, she had around 6 drinks, isn't that right? That was a yes?
Yes.
Then you left at around 11:45?
Yeah, we did.
You said that you didn't feel safe getting in a car with Jessica, right?
No, not at all. I mean, to me, she looked obviously drunk.
But Jessica said that she'd gotten pretty good at driving after a big night. Isn't that right?
Yeah, but I don't think she was thinking rationally at that point, and no one was saying anything to her. They were just kind of.
Well, Miss Levin, that's not what I asked. I just asked if that's what she said. That was a yes.
Yeah, that is what she said.
And then she refused to get in an Uber with you.
Yeah, she ended up getting into her car.
All right, and then after this, Jessica got in her own car, like you just said.
Yes, she did.
And then she drove away.
Yep, she did.
Thank you, Miss Levin. I have no further questions.
Okay, and Ms. Hill, you'll forgive me. I don't know if there's redirect allowed, or if it's not. If it is, you may do it. If it's not, then call your next witness.
Yes, Your Honor, just a brief redirect.
You may. Go ahead.
Now, Ms. Levin, on cross-examination, you were asked about some of the symptoms that you saw in Miss Marks that evening. I just want to clarify, what was it that you saw in Miss Marks that evening that led you to believe that she was drunk?
I mean, she wasn't acting like herself at all. Like, she was slurring her speech, talking really loudly. Her eyes were red, watery. And then she literally fell down the stairs in front of Sunny, and he just laughed it off. You don't just fall down the stairs.
And finally,
Sorry.
pardon, were you done speaking?
To me, she looked obviously drunk.
Thank you. Nothing further, Your Honor. May this witness step down?
She may. Thank you, ma'am. Thank you, Ms. Levin. And Ms. Hill, you may call your next witness.
The plaintiff doesn't have any more witnesses to call. At this time, we rest, Your Honor.
Okay. Plaintiff has rested. Does the defense have a case? And does anybody need a break in between? I could take a couple minutes if you want to, or we can go straight through.
I'm ready to proceed, Your Honor.
Okay. Then call your first witness, ma'am.
Yes, Your Honor. The defense calls Sunny Mehta to the stand.
All right, Mr. Mehta, you've been sworn. Ms. Moore, when you get, I guess, situated, you may proceed.
Now, good afternoon, Mr. Mehta. Could you introduce yourself to the court?
Hi, my name's Sunny. I'm an entrepreneur slash mixologist slash comic book enthusiast. Nice to meet you.
All right, and are you currently employed, Mr. Mehta?
I'm kind of between projects at the moment. Like I said, I'm an entrepreneur, but I used to be the owner and operator of a place called Sunny's Rooftop Bar, named after yours truly.
And could you tell us why you're here in court today?
Yeah, apparently back in 2019, we served this one girl, and apparently she had used a fake ID, and she was good at hiding that she was drunk, and when she left, she ended up getting hurt. She ended up dying. So I'm here to explain what happened that night.
All right, well, I'd like to talk to you about that a bit. You mentioned that you served Jessica Marks that night. Did you?
I did. I'm sorry.
And I'd like to get straight to the point, Mr. Mehta. At any point during the night, did you observe any signs of obvious intoxication in Jessica Marks?
No, I've thought about that night a lot of times since, and they just weren't there, the signs.
All right, and before we get to how you make the distinction of whether someone isn't obviously intoxicated or not, I'd like to talk to you about some things we heard today. You are here for the testimony of Morgan Levin, isn't that right?
Yeah, I was.
You heard Miss Levin say that Jessica Marks stumbled into you on the stairs. Did this ever happen, Mr. Mehta?
No, I've thought back on that night so many times, and nothing like that ever happened.
We also heard Miss Levin say that you said you might have to cut Jessica off. Did you ever say this, Mr. Mehta?
Of course not. I would never joke about something like that, someone's life.
And could you tell us about Morgan Levin's demeanor that night?
Her demeanor. Yeah, Morgan, she was a pretty buzzed party girl. She was swaying a bit at the end of the night. It wasn't at first, but towards the end, I started to get a little concerned.
All right, now I'd like to switch gears and talk to you about how you distinguish whether a customer of yours is obviously intoxicated or not. When you became a bar owner, did you have to undergo any sort of training?
Yeah, I did. So the state of California required that I go through a training, and all of my servers go through a training through the responsible beverage service. And then I had to take an exam proctored by the state. And then I have to renew that exam every 3 years. And I've kept that current up till now.
Well, what did you learn in order to take this exam?
There was a lot of things, but one of the main parts was learning to recognize when someone meets an objective standard of being obviously intoxicated.
Your Honor, do we have permission to display a demonstrative aid?
You may, to the witness or to the jury or both?
Both.
Okay, so would you like to create a demonstrative, or is it something that's already been created?
It's already been created.
Okay, could you just, I guess, let's go outside the presence of the jury. Could you tell me what it is?
It's just a list of the signs of obvious intoxication.
Okay. Is there, I don't have an issue with it unless the plaintiff does. Ms. Hill, is there any objection to that?
Your Honor, we didn't have a chance to go over demonstratives before this trial, so I would just ask that I'd be allowed to see this demonstrative before it's displayed to the jury.
Sure, that's fine. We're outside the presence of the jury. If the second chair could please display the demonstrative for the court and opposing counsel.
The plaintiff has no objection to this, Your Honor.
Okay, perfect. Then, Ms. Moore, you're going to be able to display that. We'll go back in the presence of the jury and you can go through it as you see fit.
Yes, Your Honor. Now, Mr. Mehta, could you tell us about some of the signs of obvious intoxication you learned about during your training?
I apologize. So there were a lot, but they would fall into two main groups. There were psychological ones and physiological ones. Physiological, think of things like that show that the alcohol was physically in the bloodstream. For that, you can look to the eyes. You can see that they've gotten red, watery, that their gaze isn't able to focus on anything. And then for psychological, you look for things that suggest some lack of inhibition. Something like speaking very loudly, or evidence of there being a sedative or depressive substance in them. That's what alcohol does. So something like slurring words or even falling down and passing out. Those are all things we look for.
All right, and Miss Waddington, could you go to the second page of our demonstrative? Thank you. You can take it down now. Now, I'd like to go back to the night of March 24th. You mentioned that you served Jessica Marks. Do you remember how many times you interacted with her?
It's hard to, I couldn't give you an exact number, but I'd say somewhere in the 8 to 10 range between taking orders and bringing drinks.
Is this an unusual amount of times to interact with the customer in one night?
No, that's typical.
And do you remember what you served to Jessica Marks and Morgan Levin?
I remember, I don't think I could give you an exact rundown, but I remember I served them a couple of drinks and I served them some guac and chips.
All right, and could you describe Jessica's demeanor as the night went on?
Yeah, so Jessica just seemed like a typical party girl, to be honest. Like her demeanor didn't really change that much throughout the course of the night. She just seemed like she wanted to have fun and she looked like she was.
Your Honor, permission to display our demonstrative again?
You may.
All right, could you get that on the screen, Ms. Waddington? Did you ever observe Jessica with red, watery eyes?
No,
Did you ever see her have a vacant gaze?
no,
What about her speech? Was it ever slurred?
no, of course not. If it was slurred, I would have had a really hard time taking her order.
Did she ever speak obnoxiously loud?
Obnoxiously? No, it wasn't conspicuous. Everyone was speaking slightly elevated because of the music, but it was totally normal.
And did you ever see Jessica Marks as much as lose her balance or even fall down?
No, not at all. It was her friend who was stumbling a lot more.
You could take that down now, Ms. Waddington, thank you. Now, Mr. Mehta, you remember seeing a video here in today's trial, right?
Right, yeah.
Ms. Waddington, could you display that for us? Now, Mr. Mehta, I have to ask, if you ever saw Jessica acting like this, would you have continued serving her?
I would have been really, really concerned about it. I try not to make judgments based on one video that was made for social media, but I really would have had serious concerns about serving her alcohol. And that's not what she looked like.
Exactly. Did you ever observe Jessica acting like this on March 24th?
No, nothing close to that. She was sober.
All right, you can take that down now. Mr. Mehta, have you ever had to cut someone off at your bar?
Of course, yeah, that's a routine thing. It's part of running a bar.
Why didn't you cut Jessica off that night?
I'm only trained to cut off people who show the symptoms. Jessica didn't show the symptoms, and So I didn't cut her off.
Thank you, Mr. Mehta. I have no further questions at this time.
Thank you, Ms. Moore. Ms. Hill, do you have a cross-examination?
Yes, Your Honor, just one moment to readjust, please.
You may proceed whenever you're ready.
Good afternoon, Mr. Mehta. I want to first confirm that you can both see and hear me all right.
Coming through clear.
Now, I want to make one thing absolutely clear. On March 24th, 2019, you sold alcohol to a minor.
I did. That's right.
You sold it to Jessica Marks.
Yeah, and her friend, Morgan Levin.
Well, I want to talk more specifically about what was sold. Your Honor, permission to display Exhibit 17 onto the screen constructively outside the eye shot of the jury.
You may.
Now, Mr. Mehta, is this the receipt that you gave Miss Marks and Miss Levin that night?
Yeah, that looks totally right.
And you gave them this receipt after they bought drinks from your bar?
Yeah,
And it's common for you to give your customers their receipts after they pay their tab?
that's usually how it goes.
So you would say that this is a fair and accurate copy of that receipt?
Yeah, it's absolutely.
Your Honor, the plaintiff moves Exhibit 17 into evidence.
Is there any objection?
None, Your Honor.
All right. With no objection, that exhibit will be admitted.
And now I want to break down what's on this receipt, sir.
Sounds good.
Now, Miss Marks asked you for a bottle of wine.
That's right.
You said yes.
Of course.
Miss Marks asked you for 3 White Claws.
Yeah, she did.
And you said yes to her again.
That's right.
And then Miss Marks asked you for a beer.
I don't remember who ordered the beer, if it was Miss Marks or if it was someone else.
But you did bring the beer to their table.
That's right, the table with both Miss Marks and Morgan Levin.
And there were 2 beers that you served that evening, right?
That's right, yeah, you can see them on the receipt.
And then finally, Miss Marks asked you for a green tea shot, right?
Again, I don't know if it was Miss Marks or Morgan Levin who ordered that.
But there were 2 green tea shots ordered.
Yes, for table 4.
And once again, you said yes.
I don't know if they necessarily asked a yes or no question, but yeah, I brought the tea shot.
Sir, you're aware that Miss Marks is about 5 feet tall.
That sounds right.
You're aware that she's roughly 110 pounds.
Based on the 30 minutes I saw her, that sounds right.
So a 5 foot, 110 pound girl ordered a bottle of wine, 3 hard seltzers, a beer, and a shot of whiskey, and you said yes to her every single time?
Again, I really can't tell you who ordered what or who drank what.
Well, you saw those drinks on the receipt, right?
I did see them, but that receipt was for 2 people.
But you did serve those drinks to their table that evening?
That's right, yes.
Let's move on. I want to talk about what was going on at your bar that night. Now, you said on direct examination, and I wrote it down to be sure, Jessica didn't show the symptoms. Did I get that right?
That's entirely right.
Well, sir, you were here when Morgan Levin testified today, right?
I was.
You were here to see a video of Jessica Marks play during Miss Levin's testimony?
I did, yeah, I saw that video.
You heard her testify.
I apologize, Your Honor. It looks like I was
No.
kicked out.
We all were. I was kicked out too. Okay. So go back to the last thing that you were saying, Ms. Hill. I'm sorry, and we'll just continue from there.
Of course, Your Honor, no problem. Now, sir, you heard Miss Levin testify that that video was taken at about 11 p.m. that night.
And that's what she said, yeah.
Ms. Perret, can we get that video on the screen? Your Honor, permission to show Exhibit 10, which has already been admitted.
You may.
And now, sir, it's your testimony today that you don't think Miss Marks looks drunk here, right?
I can't say that for certain.
But you don't believe that Miss Marks looks to be obviously intoxicated here?
No, this is a video for social media. You can't really make a judgment based only on that.
Well, sir, I want to make sure that we're watching the same video here. You saw Miss Marks put her sunglasses on at this video?
That's right.
You saw her put her sunglasses on at 11 o'clock at night?
That's right. She was playing a role, trying to be funny for her friends.
Is that a yes?
Yes,
And then you saw her look off camera.
that's right.
You
Playing a
saw
role.
her. You saw her look off camera and give a mock Academy Awards acceptance speech.
That's right.
And you heard her in the beginning saying that she's at a bar in Hollywood, right?
Yes,
And now, sir, your bar's actually in Malibu, isn't it?
that's right.
But regardless of any of that, it's still your testimony today that you don't think she looks drunk here, right?
I don't think you can make that judgment from this video.
Is that a no? You don't think she looks drunk here?
No. Or yes, that's a no to your question.
I want the members of the jury to know what was going through your head while this video was taken. You know that you can't sell alcohol to a minor, right?
Of course.
You know that it's your job to cut someone off if they've had too much to drink,
Yes,
but it was your decision not to call an Uber for Miss Marks.
that's right.
It was your decision not to try to stop her from getting into her car.
No, I wouldn't stop someone who didn't show symptoms.
That's a no. You didn't stop her from getting into the car.
No,
It was your decision to stand still as Miss Marks and Miss Levin walked out of your bar, right?
that's right.
Well, Mr. Mehta, isn't it a fact that about an hour after this video was made, Jessica Marks passed away? A yes or no?
Yes,
Nothing further, Your Honor.
Okay, Ms. Moore, you got any redirect?
No, Your Honor.
Okay,
And
Then
with
call
that,
your-
the defense rests its case.
okay, the defense is rested, the plaintiff is rested. We will now move to closing arguments. If y'all are ready to proceed, then we can start with the plaintiff's close.
Could we get a brief 2-minute bathroom break, Your Honor?
No, yes, absolutely. If y'all want to break, that's fine
Thank
too.
you.
Let's take 2 minutes.
Your Honor, according
ma'am.
to the rules, we're more than happy to take a break if Your Honor would like, but as counsel, we're not formally allowed to request breaks.
Okay, I had asked before and I would have taken a break before because I need to go to the bathroom as well. So I appreciate that, but I would like to take a couple minutes. So
Sounds good, Your Honor.
yes, ma'am. Thank you.
Pardon, Your Honor, I don't think we can hear you.
Your Honor, we can't hear you still.
Okay, can you hear me now?
Yes, Your Honor, we can.
Okay, good. I'm sorry. My thing got connected to something else. What I was saying is just making sure Ms. Jacoby's back, which it looks like she is.
Yes, I'm here.
Okay, perfect. So we can go ahead, Ms. Hill, whenever you're ready.
Yes, Your Honor. 6 drinks. This defendant's owner served Jessica Marks 6 drinks. In less than 3 hours, Miss Marks was served a bottle of wine, 3 hard seltzers, a beer, and a shot of whiskey. And we're standing here today because of what this defendant didn't do in those 3 hours. What Miss Marks didn't know was that this bar knew how drunk she had become. What she didn't know was that this bar had a legal responsibility to cut her off. But members of the jury, you do. You listen to the evidence and you know that they sold Miss Marks alcohol. You listen to the evidence and you know that they saw her become obviously intoxicated. And you listen to the evidence to know that instead of saying stop, they stood still. They sold, they saw, they stood still. That's why we're here today. Today we brought a claim of wrongful death against the defendant, Sonny's rooftop bar. Today it was our job to prove, more likely than not, that this defendant caused the death of Miss Marks. We had to prove that this defendant sold alcohol to a minor, that they saw her become obviously intoxicated, and that they stood still. We've met our burden. Let me walk you through everything we've heard today. Starting with that first fact, this defendant's employees sold Miss Marks alcohol. Today, this fact isn't in dispute. Ms. Moore and I agree that on March 24th, 2019, Miss Marks was 19. We agree she was a minor. But more importantly, she was a minor that this defendant sold alcohol to. You heard from both witnesses and saw on a receipt that Miss Marks was served a bottle of wine, 3 hard seltzers, a beer, and a shot of whiskey. She drank all of that in less than 3 hours. Now, members of the jury, laws are here for a reason. Laws say that a 19-year-old can't walk into a bar and drink as much as they possibly want to. Because when you break these laws, you risk someone getting hurt. And when you choose to ignore every sign of obvious intoxication, you risk a human being losing their life. That brings me to my second point, that this defendant's employee saw Miss Marks become obviously intoxicated. And now you heard from Morgan Levin about all the symptoms Miss Marks was showing. You heard about the slurred speech, the bloodshot eyes, and the stumbling. This defendant's owner, Sonny Mehta, has tried to say that he didn't see any of these signs. But members of the jury, you saw it for yourself. Can we pull up that video, Ms. Parak? Members of the jury, you saw this video. You saw her slur her way through a mock Academy Awards acceptance speech. You saw her put her sunglasses on at 11 o'clock at night. You even saw her forget what city she was in. Now, if Mr. Mehta insists that he couldn't see these signs, then it's because he wasn't bothering to do his job. In fact, you have evidence on the record to prove that's exactly what happened. Let me bring it back to what Ms. Levin told you. She told you that Miss Marks was so drunk that she fell down the stairs and Mr. Mehta had to catch her. But instead of looking over at his bartender and taking his job seriously, he saw it as a time to joke. You heard that he looked over at the bartender and said, "Whoa, we may need to cut this one off." And then he laughed. And by the time he was done laughing at Miss Marks, he was already back to serving her. He just couldn't stop saying yes. And that third fact, this defendant's employee stood still. Today, this defense's own witness, Sonny Mehta, admitted that on March 24th, it was his decision to continue serving Miss Marks. It was a decision that lost him his business, a decision that lost him his liquor license, and a decision that lost Miss Marks her life. Now, the defense has tried to say that it was because of Miss Marks's choices that this happened. But whatever way the defense tries to spin this, it lands on liable. Because while Miss Marks may have made the choice to drink and drive, it was this defendant's employees that made the choice to let her get to the point that she shouldn't have been allowed to drive. The defense wants you to believe that Miss Marks walked out of that bar looking stone cold sober. But think about it, members of the jury. She couldn't make it 1,000 feet from the bar before she crashed. There's no way she walked out of that bar looking sober. There's no way she walked out of that bar without stumbling. There is no way that it was her choices that caused her death. The only way that Miss Marks died was because this defendant sold, saw, and stood still. They sold her those 6 drinks. Now make them pay the price. Find this defendant liable. Thank you.
Thank you, Ms. Hill. Ms. Moore, do you have a closing argument?
Yes, Your Honor.
You may proceed when ready.
May it please the court? We all make choices, but in the end, our choices make us. Sadly, members of the jury, these words ring all too true for today's trial. From the choice to drink before going to Sonny's, to the choice to drive after drinking, to the choice to order 6 to 8 drinks, to the final fatal choice to choose to drive home. These were Jessica's choices. No one made these choices for her. And these choices led to Jessica's untimely and unfortunate passing. But members of the jury, nonetheless, these were her choices. And that is the reason why no one else can be held at fault here today. Unlike the plaintiff wants you to believe, Sonny Meta didn't hand these drinks to Jessica. Jessica ordered these drinks. And when she ordered them with the intent to go big or go home, when she said these words, she sealed her fate. She said them a mere hours before she unfortunately died in a drunk driving accident. Now, members of the jury, the plaintiff told you a fanciful tale here in today's case. They told you that Jessica Marks was showing signs of obvious intoxication the entire night. They told you that Jessica Marks stumbled into Sonny Meta. And they told you that Sonny Meta joked about Jessica needing to be cut off. But members of the jury, let's examine where these memories are coming from. These memories are coming from Morgan Levin, who was a distraught best friend at her own admission, but recalling these events a year and a half later. These are coming from Morgan Levin, who doesn't remember and even misremembers things about the night of March 24th. And this is coming from Morgan Levin, who spoke with plaintiff's attorneys for upwards of 3 hours the day before giving her deposition. Then when asked by my co-counsel, she said that all she remembered from this conversation was to tell the truth. A 3-hour conversation to be reminded to tell the truth? Well, members of the jury, it's quite a coincidence that Ms. Levin remembers more about 3 hours that happened 17 months ago, the 3 hours that happened the day before she gave her deposition. But you know what Ms. Levin did remember? She remembered to use the correct legal terminology when referring to Jessica Marks. She remembered to refer to Jessica Marks as obviously intoxicated. Now, I want to talk about Jessica Marks. You are shown a video of her here today that shows her with slurred speech and acting with a loss of coordination, but you heard Sonny Meta. Sonny Meta said that He can't make any judgments about a video that was made for social media. And you shouldn't either, members of the jury. You heard Jessica in this video. She thanked the Academy. She said she was in Hollywood. This is because she was acting. You know who wasn't acting, members of the jury? He said Marks wasn't showing any signs of obvious intoxication. Now, we learned some things about Morgan Levin's life, about Jessica Marks's life from Morgan Levin. She told us that Jessica Marks drank every Saturday while she was in high school. She drank so much that she had Morgan Levin as her designated driver. And she began to drink more when she got to college. Now, members of the jury, because of these facts, you must recognize we aren't dealing with a typical teenage tolerance to alcohol. You're dealing with someone who could conceal the symptoms of intoxication. You heard what Jessica said to Morgan. She said, "I've gotten pretty good at driving after a big night." Jessica had done this before. She had driven drunk before. And Sunny Meta said he saw no signs because they weren't any. But let's talk about Jessica's choices again over the course of the night. Jessica Marks drank before she came to Sunny's rooftop bar. She drove after initially drinking. And she ordered 6 to 8 drinks herself while she was there by her own volition. And then she refused an Uber from Morgan Levin. Then she made the fatal choice to drive home. Now, members of the jury, a few moments from now, you will be asked to make a choice. You will have to decide who is more than 50% responsible in today's case. And in doing this, I ask you to take a look at the facts that you have been presented with and who these facts came from. You heard from Sunny Meta, who was the only sober person at the bar that night. And you heard from Morgan Levin, who was drinking herself that night. And you need to decide whose testimony you should trust. Members of the jury, I ask you to find Sunny's Rooftop Bar not liable for Jessica's choices. Thank you.
Thank you, ma'am. I don't know if there's any rebuttal. If there is, you may do so. If there's not, then let me know.
Yes, Your Honor, just 1 minute to readjust.
Sure.
May I proceed, Your Honor? We all make choices, but it's our choices that make us. That's what Ms. Moore told you today. And as it turns out, I couldn't agree more. So let's take a look at those choices that the defendant's employees made. They chose to serve her those 6 drinks. They chose to ignore the stumbling, the bloodshot eyes, the slurring of words. They chose to not call Miss Marks an Uber, to not stop her from driving away in that car. Now, today I'm not denying that Miss Marks ordered these drinks. But don't forget, it wasn't Miss Marks, but the employees of Sunny's Rooftop Bar that had a legal responsibility to cut her off. Ms. Moore has just come up here and criticized the credibility of Miss Levin. But she criticized her for remembering what happened the day that her best friend died. Of course, Miss Levin remembered, but Mr. Meta didn't. Don't forget when he referred to her as just some girl. It was the defendant's employees that sold, saw, and stood still. Thank you.
All right, right on time. So I think now at this point, it's up to the judges to fill out their ballots. I believe the bailiff can correct me if I'm wrong. And if once we're done with the ballots, then we'll get to a few critiques and be done. If I'm correct.
Correct, Your Honor.
All right, perfect. So I'll come back on. I'll come back on. I'll give about a couple minutes to fill out the ballots, and I'll come back on, and then we'll check with Ryan and make sure that they're all in before we start.
Yep, I'll give you all the all clear.